Justice Barrett? Justice Jackson?
I'll just ask you, in response to Justice Barrett, when she asked about the chill theory, you said there were two problems, one of which is the fact that there's a merits connection, and that you saw as a problem. I guess I'm still struggling to understand why the pre-enforcement theory and the aspect of injury that relates to the possibility that you're going to be ordered to disclose, why isn't that also bound up with the merits? I mean, it will only happen if you are wrong on the merits of your challenge. So I see, for example, the litigation cost theory of pre-enforcement, that you're going to spend this money and it's not bound up with the merits. You've got to do that anyway. And so I understand that as a potential injury, notwithstanding Justice Sotomayor's point about you having to incur it anyway. But the idea that you're going to be injured because there's the possibility that the court will rule against you seems to me to be bound up in the merits.
No, Justice Jackson.
No. Okay. Why not?
Pre-enforcement challenges are a staple of federal litigation. And in those challenges, what a court does is simply ask, is there a threat, a reasonable, objective threat, that the state will begin proceedings or that the prosecutor will begin proceedings? To determine standing, you don't need to make a further inquiry into how likely it is that...
And that's because you're injured because they brought the proceedings? Is that that's the injury you're saying?
That's the injury.
Okay. Thank you.